patent sucks because you didn't protect yourself when you're dealing with third parties. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please like, follow, and share. When you're in the early stages of developing an invention, a lot of times you might need help from a third party, like a design house, an engineering firm. A lot of inventors come to me who are good with the broad strokes, but they're not good at a lot of the enabling details that you have to file a patent application. So they want to go for outside help, which in and of itself is fine. But when you do this, you have to protect yourself because you are naked. When you go to them and just disclose your idea, you don't want to do that. There's nothing to prevent them from running off with it. There's no such claim you can make that was my idea first and they took it. That's not a claim you can make. There are idea theft claims in certain states, but they basically end up being like breach of confidentiality agreement claims, more or less. So what do? First thing, make sure you have a patent application on file, at least a provisional. Now, if you're going to the third party because you can't really flesh out the details of your invention, it may not be the world's greatest patent application. You just do the best job you can with what you know. It's a bit of a chicken or egg problem if you're in that situation, but file something that discloses your idea to the best of your ability. Second thing, have them sign a non-disclosure agreement, obligating them to only use the information you provide them for purposes of working with you and prohibiting them from filing for patent applications based on it, creating products based on it, etc. I know a lot of you are going to run to the internet and grab the first form you can find. I would caution you against that unless you read it carefully and know what you're reading. That can get you into trouble. There is no single non-disclosure agreement. It can be whatever you want it to be, and there's all sorts of ones all over the internet, and they may or may not fit your situation. You want one that's going to reflect your situation as much as possible and be tethered to the information you're providing to give you the cleanest case possible, because it's going to be a breach of contract case. That's what you're going to have if they violate the NDA. Why do you do that? Because that pending patent application gives you zero enforceable rights. Let me say it again. A pending patent application, be it provisional or non-provisional, gives you zero enforceable rights. So unless you have an NDA, which gives you a contract right, you've got nothing. So make sure you do that. Now, the third piece is that if you do work with one of these firms, make sure you get them to assign the intellectual property rights they develop on your behalf to you. Just because you pay them does not mean you own the IP that they develop on your behalf. The law is not set up that it creates an automatic transfer. The way it works is if you eventually file an actual non-provisional patent application with claims in it, if that third party contributed to the subject matter of any of those claims, legally they are and must be named as an inventor, no matter what. If you don't do that and you get a patent, it can be invalidated for failure to state the proper inventorship. And or if you get a patent, that person can go to court and say, I should have been named as inventor, and file an action to get put on the patent. Once they're on the patent application, they are a co-owner. So you have to have them assign their rights to you so that when you satisfy your legal obligation to name them as inventor, you're not giving up ownership. All right. So this probably isn't something you want to do on your own. You want certain language in there to make it as bulletproof as possible, but you definitely want to get them to assign their rights to you. But it's really important in this initial stage, because this is the point where people get ripped off. Now, not everybody's going to want to sign an NDA because that exposes them to liability. Depending on who you go to, they may have enough business that they don't feel like they have to sign an NDA, and they don't. So you may just decide to take your business elsewhere. The same thing with the assignment. But if they're going to take that position with you, you should be doing business with them anyway. Okay? So make sure to protect yourselves when you're dealing with those third parties. I hope that helps to keep you out of trouble, and I hope to see you here soon.